Woodrow Wilson said some 100 years ago that the Supreme Court is the balance beam of the whole constitutional system. Yet, some 100 years before that, in 1787, Alexander Hamilton called the judicial branch the least dangerous branch of the United States government. Well, how can this branch go from being virtually powerless to being one of the most influential within the constitutional system? Taking a look at the creation of this branch might help us understand why.
Article 3 of the Constitution gave America its judicial branch when it said,
"The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." Which means, hey everybody, how's about a government branch that interprets our laws?
When this part of the Constitution was first written, not all citizens agreed to this court system. There were two main schools of thought, the Federalists and the Anti-Federalists. Alexander Hamilton was a Federalist. He and all his Federalist buddies saw the new Supreme Court as the least harmful branch in the government. But the Anti-Federalists weren't so blasé about the whole thing. The Anti-Federalists felt that a branch of government made up of people with a lifelong tenure was dangerous, especially since they had the power to interpret the meaning and importance of the supreme law of the land. Supreme Court justices would be justices until they died or stepped down from office according to the Constitution.
Well, the Anti-Federalists did have a point. Article 3 was a bit vague when it came to the structure of the Supreme Court. That's why, in 1789, the Judiciary Act of 1789 was passed.
The Judiciary Act of 1789 established the three-tier structure of the federal court system. Those three tiers include the federal district courts, the circuit courts, and the Supreme Court.
Before we get any deeper into the world of the judicial system, you should know a quirk of the American legal system.
Specifically, the American legal system has made several names for itself. The first name is the dual system. You see, while there are all those federal courts and the courts of appeal and the Supreme Court, there's also another arena for law in this country, and this is thanks to the dual system.
The dual system consists of the federal court system we just outlined and the individual judicial systems at the state level.
Secondly, known as the three-tiered system, the American judicial system contains three different levels of courts within both the federal and state levels. Each tier has a different jurisdiction.
They are the trial courts, the appeals courts, and the Supreme Court.
Let's see how each of these courts fit together to form the big judicial system.
The federal district courts are the lowest level courts on the federal tier. There are over 94 federal district courts in the country and at least one in each state. What does the authority of the federal district courts include? First, those cases that deal with a federal question whose issue is based on a claim within the U.S. Constitution. Second, cases where the plaintiff or the defendant is the federal government. And third, cases involving diversity of citizenship, meaning cases with people from different states or where the issue involves more than $50,000.
It's in the federal system where most of the big legal work of America occurs. But what happens when the people involved in a case within the federal district courts aren't happy with the outcome? They can move on up to the second tier and take their griping to the circuit courts in the form of an appeal.
The circuit courts, also known as the appeals courts, include 13 courts in the United States. These are courts which have no original jurisdiction.
Now, original jurisdiction refers to a court's authority to hear cases for the first time at the trial level. This is what the federal district courts have.
Instead, the appeals courts have appellate jurisdiction, which refers to the authority to review a case which has already been decided at the trial level. One thing to remember is that the appellate courts determine what laws apply to a case. District courts, on the other hand, determine the facts that decide a case. Appellate court cases are usually heard by a panel of 3 judges with no jury. District courts, on the other hand, are made up of 1 judge, and in the case that a trial is held, a jury of the defendant's peers.
So, getting to the appeals court is like getting another chance in the bull ring. There are 2 types of cases heard at this level. Those involving cases from federal district court and those involving issues in federal administrative agencies.
But what happens if after you've made it to the appeals court, you're still not happy with the decision?
You can try your best to take your case to the third tier, the Supreme Court of the United States. The Supreme Court of the United States includes 9 members, 1 Chief Justice, and 8 Associate Justices.